Simpkins et al.
Good morning.
Morning. May it please the court, Irene Hayudi of the Nashville Bar here on behalf of the appellants, the Barrios. And if I may, I'd like to reserve 2 minutes for rebuttal.
2 minutes, yes, ma'am.
Thank you. This case involves a property dispute between neighbors, and one of the central issues was the determination of the property line. There were also some tort matters involved, including a claim of outrageous conduct, a claim of assault, and a claim of trespass, lots of claims of trespass. And on the claim of trespass, one item of testimony that the court may consider central in its final resolution of the case is the appellee's testimony set forth in page 14 of my brief. In that case, the appellee, Mr. Simpkins, testified, quote, "I've never been across that Jeff Chandler survey unless I was turning around there, because I mowed that away sick sometimes, and if a tire went over it, I didn't know it." There were several surveys involved, and the ultimate survey that was adopted was not the Chandler survey, under which appellees operated, but it was the survey of my clients. So every time he mowed under the Chandler survey, he trespassed, we would submit. So that may cut through some of the controversial testimony. In addition, my clients advocated at trial for 2 alternative property lines. The first property line that they advocated for was the survey they had submitted. The alternative property line that they advocated for was the property line that they were shown when they purchased the property 20 years prior. They purchased the property about 20 years before trial, and the appellees purchased their property in 2013. Now, because one of the issues involved is whether injunctive relief should have been granted and whether damages should have been granted, it is important to look at a specific statement of the trial court that we would submit as a basis for various of the errors we're complaining about. On page 4 of the brief, the trial court is quoted as stating, "Since there was a dispute as to the rightful owner of the property, there could not be a wrongful entry on another's real property." We would submit the fact that property is disputed does not permit trespass, and a trespass occurs every time the person who incorrectly enters that property does so.
So what was the proof then that there was trespass on the property, that they were actually on property that the court later determined belonged to your client?
There was a testimony I just quoted. There was a testimony of a neighbor who observed rocks being thrown by appellee husband onto the area that is mowed. There was a testimony of the handyman who did the mowing, who testified for the first 2 years after the appellees purchased the property. He had lots of problems with rocks, and there are numerous pictures that parties testified to.
And so, but how, I mean, so the property boundary is a visible line, though. I mean, how did they distinguish between, and your client's advocating for 2 different lines. So did you, I mean, were they asked under the original purchase line, were they over the line? Or, I mean, how was that distinguished
They
in
were
this
asked
case?
both, and my client's surveyor actually put a blue series of flags out that represented the line that the Barrios were shown upon purchase, and then he pointed out his survey line. And that was different from the Chandler survey line in the far back up to 36 feet.
And so there was testimony that they were past these blue flags then?
And also past the survey line that was adopted.
Okay.
So you're saying the blue flags were still there?
No.
Okay.
The surveyor that my clients hired was asked by my clients to not only perform a survey, but also to set out a series of different colored flags, blue flags, that represented what my clients were told the property line was when they purchased the property. And they had used that land since purchase.
But some color of flags were there when rocks were being thrown that somebody witnessed?
No. We have testimony of a neighbor who observed a Pele husband throwing rocks onto the property that my clients mowed. And that would be their property within the adopted survey. And a second person connected that testimony by stating that he mowed the property for the Barrios, and when they did so for the first 2 years after Epelis purchased the property, he had lots of trouble with rocks getting into the mower. Going back to the trial court stating, since there was a dispute as to the rightful owner of the property, there could not be a wrongful entry on another's real property. There is a large body of case law in Tennessee that says the intent for a trespass is not the intent to trespass, it is the intent to be physically present where you are. And that case law is cited in the brief, and it is directly contrary to what the trial court held in its opinion. So we would submit that that is the basis for reversing a large portion of the trial court's ruling. In addition, the trial court stated in its opinion that when there is a trespass, the party being trespassed upon has a right to at least nominal damages. The trial court acknowledged that as being applicable law, but failed to award any damages whatsoever in this case. My clients also asked for injunctive relief because it had become a situation where no matter what they attempted to do, they could not solve the problem of trespass on their land going on over and over and over again. At one point, right before they filed this lawsuit, they came out of their house on a Sunday morning going to church and saw that a bunch of trees were cut down on their property line. So the proof is not only of trespass once the survey was adopted and we knew where the property line was, it is also of damages.
Excuse me for interrupting, counsel. Was there a specific amount that your client requested as nominal damages at trial?
No, Your Honor. My client asked for up to $250,000 in damages overall, and that includes a claim for assault and a claim for outrageous conduct. They were awarded zero in damages, and when we look at the case law for nominal damages, they should have been set at least at that amount. And if we look at the proof that was submitted in terms of damages, Ms. Barrios testified she had trouble sleeping, that she was stressed out, that the most scary event she ever went through was when she was assaulted by a lawnmower that was driven by Mr. Simpkins. Mr. Simpkins denied that in his testimony. And she had a medical bill of about $1,500 presented with regard to that, to which no objection was made. And then she had some testimony about the stress and the inability to sleep and the other negative factors as a result of this ongoing neighbor dispute.
And that's referring to the incident where the lawnmower ran over her foot?
Yes, she claimed assault. Mr. Simpkins denied the assault, and the trial court found that there was no assault. The trial court also, interestingly enough, found that everybody was credible. So we cannot base that finding on a credibility determination that was made adverse to my client.
With respect to the cutting of the trees, the cutting of the timber, were the flags in place?
No. That was before the lawsuit was filed. So at that point, the surveyors had not been completely done with their work or even hired. However, if the issue in the court's mind were notice, prior to the cutting of the trees, there were other incidences where the parties exchanged verbal information and disputed the property line with each other. So both sides were on notice that there was a dispute. Yet the trees were cut down even though there was an awareness between the neighbors that there was a dispute as to where the property line was.
Now, on appeal, you're not challenging the boundary line as set by the trial judge.
Yes and no. We are asking that the boundary line, as the Barrios perceived it was when they purchased the property, be made the property line, because at trial, the Simpkins dropped all claims against the Barrios. So we proceeded on the claims against the Simpkins only, and the deed of the Barrios and the deed of the Simpkins both were made exhibits, and if we look at the Barrios deed, that deed was well over 7 years old at the time the trial took place. So at that point in time, because they had used that property as they thought they purchased it, we contend that the Simpkins would be barred by the 7-year statute of limitations from trying to take any claim to that property by adverse possession. So our preference here would be for the court to use the blue flag line as the ending point, because this is a property they believe they purchased, and we believe that even if it were wrong, they had it by adverse possession. The issue that is only addressed in the reply brief filed by appellants is whether this is a frivolous appeal. We would submit, Your Honors, that this is not a frivolous appeal, and that cases with the information that just was provided to the court, both in brief and verbally, that that is a case where if there were any finding that the appeal is frivolous, it will really hinder the development of the law and just claims being raised in an appeal. In addition, Your Honors, we are asking that the court award the Barrios their attorney's fees, but that is in the sound discretion of the trial court, of the Court of Appeals, so we're not going to belabor that point. But I would like to point out that the law is very, very clear with regard to the intent requirement, because we have the case of City versus Townsend, where somebody's in the river, wants to get out of the river, and trespasses on somebody's property. That was a criminal statute that he violated, a criminal trespass statute, and the courts found beyond a reasonable doubt that the only intent requirement was to be present where you are. And we have no proof here that Mr. Simpkins did not wish to be where he was. And he admits that he mowed the Chandler survey, which is not the correct survey, and he admits he was in the property of my clients. And that City of Townsend case has been applied to civil cases as well, and those cases are cited. So we have several errors of law and abuses of discretion where the trial court said, yes, you're entitled to this, but did not award it. Thank you.
All right, thank you, Ms. Hody. We'll now hear from the appellee, Mr. Hunt. Good morning.
Nathan Hunt, Montgomery County Bar. May it please the court, I'm here on behalf of the appellees Charlie Simpkins and Jackie Simpkins. If I could take a moment to address some of the issues that were brought up by appellant's counsel. This was, at essence, a property line dispute case. It was filed July 31st of 2014, so it is just over 8 years old as we're here today before the court. And the issue primarily was about the boundary line. There were 4 different surveyors that were hired by these parties to determine this boundary line at issue. 3 of these surveyors were hired by the appellants, and 1 surveyor was sort of rehired by my clients. That surveyor had originally been there, Jeff Chandler, at the request of the previous owner of my client's property to provide a boundary line, and then my clients rehired Mr. Chandler again once this boundary line became an issue to sort of resurvey the property, for lack of a better term. The other 3 surveyors were hired by the appellants. 3 of those surveyors testified at trial. Jeff Chandler testified, Billy Ray Suter testified on behalf of the appellants, and Brian McCain also testified in this matter as well. Mr. Suter and Mr. McCain were both hired by the appellants in this matter. The case is, if you looked at it from a bird's eye view, you would think it would be my clients who would want to file this appeal. The boundary line that was adopted was the boundary line of Mr. Suter, which was actually the appellant's surveyor. So the appellants presented their expert surveyor. He was qualified as an expert. He testified this is the boundary line. My client had a surveyor who said it's in a different place. It's not where Mr. Suter says it is. There were a number of different markings that were introduced at court with different colors to show where each surveyor thought the boundary line was. And then there were flags next to that, which is where Miss Barrios thought the boundary line was. I specifically questioned Mr. Suter at trial about that, and he said that he believed the boundary line was where he marked it, that those other markers were put there at the request of Miss Barrios, but in his expert opinion, that is not where the boundary line was located. Also, the pin in the front of the property that was an issue at trial, Mr. Suter said, I believe this front pin is where Mr. Chandler, my client's expert surveyor, says that the pin is. The pin that's 8 feet over further on to this property, I don't know how that pin got there. It doesn't have a survey marker. To my knowledge, it wasn't done by a surveyor. So there was no proof at trial that any surveyor had put this pin 8 feet further over than where it was. And all the surveyors agreed the front pin was where Mr. Chandler, my client's surveyor, said that it was. But nevertheless, my clients didn't file the appeal. They wanted the boundary line established. There's now an established boundary line after this case being in dispute for 8 years. There was an established boundary line established by the appellant's surveyor. Now the appellants come in and say, well, we want this property that's further over because we believe that we adversely possessed it. Well, there's nothing in these deeds that states that the appellants had any right to this additional land that they are requesting. And as I previously stated to the court, their own surveyor said that it wasn't where they believed that it was. Also, there was no proof at trial that the appellants had maintained this boundary line or this property that was in dispute. There was a lot of conflicting testimony at trial about who had maintained sort of this area, who had cut the grass for this area in dispute, who had maintained it over time. There was no proof that either of the parties had exclusively maintained this property during that time period. Appellant's counsel brought up an issue about my client, Mr. Simpkins, admitting to mowing over or being on the appellant's property. I would disagree with that. He said that he mowed towards Mr. Suter's line. There was a lot of testimony by Ms. Barrios, the appellant at trial, about these acts that had occurred by Mr. Simpkins. Running over her foot was one of the main allegations that was introduced at trial. It's interesting to note, too, that matter was presented to the grand jury, and there was no true bill returned on that. And as this court knows, the only person that would have been available at the grand jury would have probably been Ms. Barrios to testify about that, and that wasn't enough to get an indictment. There was certainly...
Is any of this in the record?
Yes, Your Honor.
Okay, so the criminal proceedings is in the record?
It is. There was the true bill that was introduced at the trial, if I recall, to show, wasn't this presented, Ms. Barrios? Was there no true bill returned? Yes, there was no true bill returned. Ms. Barrios showed pictures where she claimed Mr. Simpkins was driving towards her on his lawnmower prior to running over her foot. I specifically questioned her on cross-examination about, do you have any photographs to actually show Mr. Simpkins running over your foot or to show he was actually on your property at the time? And her testimony was no. Also asked her a number of times about the tree cutting that the court had asked about the burning of tree stumps and things like that. Ms. Barrios could never produce any photographs to actually show that any of this occurred on her property or the disputed area.
Excuse me for interrupting,
Yes,
counsel. What evidence was there with respect to the rocks or the alleged throwing of the rocks?
Your Honor, Ms. Wagner was a neighbor across the street who was called by the appellants. She testified that she witnessed Mr. Simpkins throwing some rocks, or I think tossing rocks was the term that was used. I asked her on cross-examination, at the time, did she know where this disputed area was that we're here on today? And she said she did not know where that was at the time. So I asked her if she knew whether the rocks were being thrown to the disputed area or directly onto the Barrios' property. And she said at the time, I did not know where those rocks were being tossed, whether they were being tossed onto the disputed area or onto Miss Barrios' property. She testified on redirect that she now knows where that disputed area is, but she testified at the time that she did not know where the disputed area was. So these rocks that were being tossed, she did not know where they were being tossed to at that point in time.
But if she knew later where it was, then she would know that the rocks were thrown on the Barrios property.
She was asked, and I think the court sort of addressed or assessed that, Your Honor. There was no specific marking back at that time about this was a disputed area, this wasn't a disputed area. And my recollection from the trial was it was pretty clear that Miss Wagner did not know where the disputed area was sufficiently to know where these rocks were being thrown. The gardener who testified, or the gentleman who maintained the Barrios' yard, testified that I mowed over some rocks. They did not used to be there. I specifically asked him on cross-examination about, did you ever see anybody throw any rocks? No. I think I even asked him about sort of the terrain out there and, what kind of terrain was it? Could rocks come up on that kind of terrain? And he said yes, that they could. So, clearly that the proof that was there didn't show that conclusively that there was any kind of trespass by my clients by throwing the rocks. The tree cutting down was before the lawsuit was even filed, and there was no photographs whatsoever introduced at the trial to show those trees were cut down on the Barrios' property itself. A lot of photographs were introduced at trial, but none of them could be established by Miss Barrios to show that it was in the disputed area or on their property. There was a lot of photographs of Mr. Simpkins mowing grass, a myriad of photographs about that, but none of them really showed where he was when he was doing it. A lot of them, even Miss Barrios admitted, yes, he is on his own property. Mr. Simpkins is on his property, mowing his grass when I'm taking this photograph. There was even one photograph introduced where Miss Barrios was behind a tree photographing my client and gave him a middle finger gesture as he was mowing his yard. So, there was all sorts of proof of animosity between these two parties. Certainly there was no proof of any kind of unauthorized entry upon the land of another. Miss Barrios had ample opportunity to show this. She clearly photographed my client constantly when he was maintaining his property. She could have easily showed, once there were survey stakes in the ground, that, hey, he's over on my property, he's trespassing on my property. The evidence was devoid of this at trial. There was just nothing to show this. The trial court correctly found that they did not meet their burden, that the Barrioses did not meet their burden to show that any type of trespass had occurred. And again, the trial court adopted their expert surveyor. They established a boundary line to move forward in this case. My clients respectfully disagree with that, but they're willing to live with that so a boundary line can be established because right now my client's property is still two vacant lots. Because of this litigation, they have not been able to dispose of their property or do anything with their property at this point in time. So that's another issue. There's also something in the brief by the appellants about their property being less marketable because of this. Respectfully disagree with that. There was no proof introduced whatsoever at trial to show that somehow their property had decreased in value or become less marketable because of these issues. In fact, they continue to live in their property with no issue at all.
The owners did not present any testimony or evidence with regard to the value of their properties.
They did not, Your Honor, other than the deeds that were introduced to show what the properties were purchased for at the time they were purchased. But as far as any kind of marketable value today or that value had been decreased because of, I guess, this litigation or what had occurred on the property, there was no proof whatsoever of that at trial. Nobody testified about what they believe the value would be today versus what it was purchased for at the time. And one interesting thing the appellants bring up is about this injunctive relief that they were requesting, that they tried to get relief and they were never able to do it. There was evidence at trial about all of these phone calls that were made to law enforcement claiming that Mr. Simpkins was trespassing on the property. And respectfully, the reason they were never able to get any relief is because they could never show there was any trespass that was actually occurring. If there was a trespass they could prove, they would certainly have the ability to get relief. They could either call law enforcement and claim that Mr. Simpkins or somebody else was trespassing on their property, or they could file a request with the trial court asking for a restraining order or asking for some type of injunctive relief. But respectfully, they've never been able to get that because the Barrios never have been able to show that any trespass occurred in order to obtain that injunctive relief. I think that's sort of the, no pun intended, the forest for the trees here is they haven't never shown any of this. They've never proven it. The trial court was correct. The Barrios has had a burden to show trespass occurred before you can move on to any damages issued. And they never showed that any trespass occurred. So you could not move on to the damages issue. One other interesting thing that occurred at trial is the Barrios has claimed that there was a terror campaign by the Simpkins, that this was the worst event of her life when Mr. Simpkins purportedly ran over her foot with a lawnmower. Mr. Barrios was a plaintiff at trial. He didn't testify at the trial. He didn't corroborate his wife's testimony about all these awful issues that had occurred, or this terror campaign that my clients had allegedly waged on them, or the fact that his wife's foot had been run over by a lawnmower and she was in this extreme type of pain or whatever. Mr. Barrios didn't test.
Is there any reason to believe that he was present to see that?
Well, he lived at the home the entire time, Your Honor.
Well, that doesn't mean he was outside.
It does not, but they were talking about emotional distress claim as well. There's an intentional infliction of emotional distress claim, and certainly their husband and wife, they lived together. He certainly would have been able to corroborate her claim about this type of emotional distress. May not have witnessed her foot being run over, but certainly if she was in distress and had to go to the hospital for this alleged event, certainly you would think his testimony would be relevant to that. And he was also a plaintiff as well. He owns this property as well. So he lived there for the 8 years this case has been in dispute also. So you would think his testimony would have been relevant if he had seen anything at all in 8 years to corroborate whether or not there was a trespass by Mr. Simpkins on to their property. Again, the issue is that these are just lots in Cheatham County. It wasn't like these were spray painted where you could tell this person is on this line or this person is on this line. The parties were maintaining properties. There was a disputed area. It was not clear what this disputed area was. There were 4 different surveyors hired to try to determine that. The key is we now have a boundary line established by an expert surveyor that the trial courts adopted. Certainly there was no proof whatsoever that any type of trespass occurred by my clients onto the disputed area and especially onto the Barrios' property. The trial court's ruling stating that the Barrios failed to prove that claim was accurate. Nominal damages could be awarded, but you have to prove a trespass occurred first.
Excuse me for interrupting. Your reference to the surveys, I presume there was a recorded plat?
There was a recorded plat.
And how many of these surveys reconciled with the recorded plat?
So what was interesting, Your Honor, is the main reason the trial court adopted Mr. Suter's survey is he actually took the entire plat for the subdivision at issue, and he counted the footage, and that's how he determined it. The other surveyors took the 2 plats that were in dispute, the 2 legal descriptions in dispute, and tried to reconcile the boundary lines based off of that. The main reason the court adopted Mr. Suter's survey is he took the plat for the entire subdivision. He added up the footage. That's how he came to his determination of where the boundary line was located. And depending on how you review it, there was a 43-foot difference in the entire thing. And I believe the court felt like Mr. Suter had accurately looked at all the plats to determine the correct boundary line.
All right.
Thank you.
Thank you, Mr. Hunt. Ms. Hody, you have some time for rebuttal, 2 minutes.
Thank you. Just a few points. First, a trial is more like a paint-by-number picture where each witness is a particular color, and when you combine the testimony of all the witnesses, you have the picture. There may not have been a photograph which says, here's the property line, here are the flags, and that is the other party on my side of the property. But we have photographs depicting the other party, plus testimony that fills in another color in the completed picture, stating that the Simpkins were on my property. In addition, not only did Mr. Simpkins admit at trial that they used the Chandler survey to determine where the property line was and that they based their actions on it. Ms. Simpkins also so testified. So if the court looks through the statement of evidence with the citations to the record and the exhibits, it will see that a paint by number comes in completely. Second, there is a difference between a survey that attempts to reconcile a deed and or a plat or two deeds and adverse possession. They are totally different colored apples. And so saying that we have this property by adverse possession would not be reflected on a plat, and it would be not reflected on a deed because it's a totally different legal concept. And that is why my clients are arguing for the property line that they believe they received. Last but not least, the idea of a missing witness may have applicability in a jury trial and may be raised there, but we would submit that whether Mr. Barrios testified or not is immaterial. The court has to look at the record in this case. Thank you.
All right, thank you. Thank you both for your arguments. We'll take the matter under advisement.